This tutorial is produced by the Mecklenburg County Clerk of Superior Court, Estates Division. While our office cannot provide legal advice, we are happy to help you navigate the estates administration process. This video will provide a step-by-step guide for completing the application and oath to open a full estate for a decedent who left a will. First, let's define some of the terms used in this tutorial with which you may not be familiar. Decedent, a person who has died. Testate, the decedent died leaving a last will and testament. Executor, the person the decedent named in a will to be in charge of the administration of the estate. Administrator CTA, a person who has been appointed by the court to administer a testate estate. This occurs when the decedent has left a will but did not name an executor, or when the person named in the will as executor is unable to perform this role. Personal representative, a person who has been appointed to administer an estate. This term may refer to either an executor or an administrator CTA. Public administrator, a county official placed in charge of the administration process of the estate. Heir, a person who is able to inherit from a decedent's estate when no will has been probated. Devisee, a person who can inherit from the decedent's estate because the decedent named the person in a will. Codicil, a document executed as an addition or supplement to a will which adds to, takes from, or alters the provisions of the will. Probate, the legal process in which the decedent's estate is administered. When is this process used? This process is used when the decedent has died with a will, and when either the decedent has left assets that are subject to probate, or an executor is needed to complete unfinished actions on the decedent's behalf. This process may also be used when a lawsuit will be filed for or against the estate, for example, a wrongful death suit. Who may apply to administer a full estate? The executor may apply for the will to be admitted to probate and to be the appointed representative of the decedent's estate by submitting the application for probate and letters. The court's approval of this application allows the executor to represent the decedent's estate. It also allows the executor to administer the estate by taking control of assets, paying the decedent's debts, and distributing the remaining assets among the devisees identified in the decedent's will. If the will did not appoint an executor, or if no executor named in the will is able to qualify as executor, the court will grant letters of administration CTA to a person who applies and is qualified to serve. The clerk will grant letters to persons in the following order of priority. The decedent's surviving spouse. Any person named in the decedent's will as a beneficiary of the decedent's estate. Anyone who, if the decedent had not left a will, would be able to inherit from the decedent. Any next of kin, with those persons of closest kinship taking priority. Any creditor who is owed money by the decedent before the decedent's death. Any person of good character living in Mecklenburg County who applies with the clerk, or any other person of good character who is not disqualified. Individuals are not qualified when the person is under 18 years of age. A court has determined that the person is incompetent and the person remains with the disability. The person has been convicted of a felony and has not had his or her citizenship restored. A corporation has applied that is not allowed to act as a personal representative in North Carolina. The person has committed an act which, under the law, bars that person from inheriting from the decedent. The person cannot read or write. The person is someone who the Clerk of Superior Court finds unsuitable to administer the estate. The person previously held the role of executor, but refused to carry out his or her duties in that role. Once the application is filed and approved, the clerk will issue letters testamentary or letters of administration CTA. The letters will allow the personal representative to take control of the decedent's assets and will confer upon this person the authority to pay off the decedent's debts, distribute the decedent's property in the manner stated in the will, and perform other acts on the estate's behalf as allowed by law. The personal representative is obligated to act in a reasonable manner that will not result in any loss to the decedent's estate and must be diligent in settling the decedent's estate. If the personal representative fails to act in the required manner, he or she may be disqualified from the role. When may the applicant apply for probate? The executor may apply for the will to be probated at any time after the decedent's death. However, if the executor has not applied for probate after 60 days since the decedent's death, a devotee or other interested person may have the option to apply. Before doing so, the devotee or other interested person must communicate his or her intention to the executor. The devotee or other interested person may apply for probate no less than 10 days after providing the executor with this notice. What documents must an applicant provide to the clerk's office when applying for probate and letters? The application for probate and letters and the oath affirmation forms must be completed and submitted to the clerk's office. Along with these forms, the applicant must also submit the decedent's death certificate, the original will, and the original of any codicils to the will. The clerk's office also requires a family history affidavit to verify the identity of the decedent's heirs. There is a separate tutorial to help you complete this form. The General Court of Justice and facilities fees for this filing total $120. Acceptable forms of payment include certified check or money order. You may also pay by cash, credit card, or debit card if paying at the courthouse. In addition to the forms mentioned, the applicant may also be required to submit one or more of the following forms. Renunciation of right to qualify. This form is used when an executor named in the decedent's will wants to renounce his or her right to serve in this role. It may also be used when a person has a higher priority of appointment as administrator CTA and wants to renounce in favor of a person with a lower priority. The signature of the person who is renouncing must be witnessed by an adult who is not a family member. If the applicant is not a North Carolina resident, he or she must also complete the Appointment of Resident Process Agent form. This form names a North Carolina resident who will be the court's point of contact if the personal representative, once appointed, cannot be reached directly. This assigned person may then receive on the personal representative's behalf any documents the court may issue concerning the estate. The assigned person must sign the appointment form in the presence of a notary in acknowledgement of his or her willingness to serve as the resident process agent. Bond. This form is used when the law requires that an executor or administrator CTA provide a bond to protect the value of the estate's assets. This is not common in a testate estate. There are separate tutorials available for each of these forms. How to complete the application for probate and letters. When filling out the forms, it is important to write the names in the exact same way on each form. For example, if a person's middle initial is written on one form, be sure to include the middle initial in all other forms that require that person's name. Inconsistent names may cause difficulties after the applicant has obtained the letters of appointment and submits them to banks, the DMV, or other agencies. If a name must be written in multiple ways, this may be done by writing all versions of the name on the form with the letters AKA between each version to indicate that an alias is being used. Enter the county where this form will be filed. Enter the decedent's name, street address, city, state, and zip code. Enter the last 4 digits of the decedent's social security number and the county where the decedent lived at the time of death. Check the first box to indicate that the decedent left a will and that the applicant is an executor named in the will. Check the second box if the applicant is not an executor named in the will. Enter the date of the decedent's death and the date the decedent signed the will. If the decedent also left a codicil, include the date the decedent signed the codicil as well. Enter the place of the decedent's death only if it is different from the place where the decedent lived at the time of death. Enter the applicant's name, street address, P.O. Box if applicable, city, state, zip code, telephone number, and county and state of legal residence. If there is more than one applicant, provide the same information for the other applicants. You may use an attachment if there are 3 or more applicants. Enter the name, street address, P.O. Box, city, state, and zip code of the attorney who is helping the applicant with this process. If there is no attorney, leave this section blank. If an attorney was listed, enter the attorney's telephone number and, if known, the attorney's state-issued bar number. Confirm that the decedent lived in Mecklenburg County at the time of death, or left property or assets in Mecklenburg County, or was a motorist who died in North Carolina, although he or she was not a resident, and that there is no other proceeding for probate or administration pending in any other court for this estate. Confirm that the decedent left a will as dated above. Check the first box if the decedent also left a codicil. In this section, you will check either box A, box B, or box C. Check box A if the applicant is named in the will as an executor, devisee, or legatee, a next of kin, or one of the decedent's creditors. Check box B if the applicant is entitled to apply for letters, or the applicant is applying after all other persons with a higher priority of appointment have renounced their right to apply. Check box C if there are others who have priority to apply for letters and have not renounced their right to do so. Since these persons have not renounced their right to apply, the applicant requests that the clerk send to these persons notice of his or her intent to apply. Box D should be used only by the county official appointed to the role of public administrator by the clerk of Superior Court. Confirm that the applicant is not disqualified from administering the estate and has not refused the right to administer the estate. Confirm that after the will was completed, the decedent had no other children and that the decedent did not marry or obtain a divorce. If this is not true, state on an attachment the facts regarding the birth of the decedent's child, the decedent's marriage or divorce, if these occurred after the decedent's will was completed. Identify any persons who are allowed to take a share of the decedent's estate. List their names, ages, relationship to the decedent, and mailing addresses. If exact ages are not known, print an A for adults or an M for minor in the age column. Once the front page of the form is completed, turn to the back page to complete the preliminary inventory of the decedent's estate. The first portion of the form includes the property of the estate. The estimated market value of the decedent's property at the time of the decedent's death is required for each field. If more space is needed, the information can be included on a separate sheet and attached to this form. List any accounts that are in the decedent's name only. Be sure to include the bank's name, each account number, and the amount remaining in the account. List any account that the decedent shared with another person, but that did not automatically transfer to the survivor upon the decedent's death. Be sure to include the bank's name, each account number, the amount remaining in the account, and the names of the other account owners. Also include the percentage of the account that the decedent owned. Include the percentage of any stocks, bonds, or securities owned solely in the decedent's name, or those that the decedent shared with another person, if the person did not get full ownership upon the decedent's death. Provide the estimated market value for any of the following assets that are part of the decedent's estate: cash and deposited checks on hand, household furnishings, farm products, livestock, equipment, and tools, vehicles, interest in partnership or sole proprietor businesses, insurance, retirement plan, IRA, etc., that are payable to the estate instead of directly to a beneficiary, notes, judgments, and other debts owed to the decedent, miscellaneous personal property, real property that the decedent has willed to his or her estate or to the executor of the estate in that person's role as executor and not as an individual. Estimated annual income that the estate will continue to earn after the decedent's death. Once all the amounts are listed, add the values in the far right-hand column together and enter the total amount for Part 1. The second portion of the form requires a listing of property which can be added to the estate if needed to pay claims. An estimated market value is required for each item of property listed. List any accounts that the decedent shared with another person if the survivor received full ownership of the account after the decedent's death. Be sure to include the bank's name, each account number, the amount remaining in the account, and the names of the account owners. Include the estimated market value for any stocks, bonds, or securities that were either transferable or payable directly to a beneficiary upon the decedent's death, or shared with another person who received full ownership after the decedent's death. Include the estimated market value for any other personal property that is recoverable by law. This category includes the following types of personal property: accounts which are called trustee accounts in the signature card or deposit agreement, or in which the decedent otherwise established a tentative or taught trust. Securities registered in beneficiary form and automatically transferred on death. Property which the decedent gave to someone in contemplation of his or her own death, and property transferred by the decedent without receiving adequate consideration, with the intent to hinder, delay, or defraud his or her creditors. If you believe there may be any property which falls into this category, you may wish to consult an attorney. List the value of real estate owned by the decedent that is not identified in any other section of the form. Once all the amounts are listed, add the values from this section together and enter the total amount for Part 2. Part 3 of the preliminary inventory includes other types of property that the decedent may have owned at the time of his or her death. Check the first box if the decedent was married and owned real estate jointly with a spouse. Check the second box if the decedent did not own real property with a spouse. Check the first box if there are any insurance, retirement plans, IRA accounts, etc. that the decedent made payable to a named beneficiary upon his or her death. Check the second box if the decedent did not leave insurance, retirement plans, IRA accounts, etc. that were payable to a named beneficiary. Check the first box if there is a potential wrongful death claim. Check the second box if there is not a potential wrongful death claim. When the form is completed, each applicant must sign the form. Do not sign until your signature can be witnessed by a person authorized to administer oaths. This will typically be a licensed notary public. Once the application for probate and letters is complete, the applicant must take an oath or make an affirmation to carry out the duties of his or her office faithfully and honestly. This is done by completing the oath affirmation form. Begin by entering the name of the county where this form will be filed. Enter the decedent's name. The applicant has the option to swear or affirm that he or she will faithfully perform the duties of an executor if applying for letters testamentary, or the duties of an administrator CTA if applying for letters of administration CTA. A person who swears to this oath would swear to God. A person who affirms would take a non-religious oath. Either version of the oath holds the same weight before the court. Read the statement in the first paragraph on the form carefully. If the applicant swears to this statement, check the first box located at the beginning of the first paragraph, as well as the first box located at the end of the paragraph. If the applicant affirms to this statement, check the second box located at the beginning of the paragraph, as well as the second box located at the end of the paragraph. The applicant will then choose his or her appropriate title when swearing or affirming. When the decedent has left a will, the person seeking to administer the estate will be either the executor or the administrator CTA. If the applicant is the executor, check the box labeled Oath of Executor. Read this statement carefully. If the applicant swears or affirms to this statement, indicate this by checking the appropriate boxes at the beginning and end of the statement. These will be the same boxes checked in the paragraph at the top of the page. If the applicant is the administrator CTA, check the box labeled Oath of Administrator CTA. Read the statement carefully. If the applicant swears or affirms to this statement, indicate this by checking the appropriate boxes at the beginning and end of the statement. These will be the same boxes checked in the paragraph at the top of the page. When the form is completed, each applicant must print and sign his or her name on the form as the fiduciary. Do not sign until your signature can be witnessed by a person authorized to administer oaths. This will typically be a licensed notary public. When the application for probate and letters and the oath affirmation forms have been completed, signed, and notarized, submit the forms for filing along with these other previously mentioned items. Death certificate, original will and, if applicable, original codicils, family history affidavit, a cashier's check or money order for $120 payable to Clerk of Superior Court. A renunciation of right to qualify form for any person with a higher priority of appointment than the applicant and who has signed the form to waive their right to qualify. If the applicant is not a North Carolina resident, the appointment of resident process agent form. A completed bond form if the personal representative is required to provide a bond. If the application is accepted, the clerk's office will issue to the applicant letters which authorize him or her as the estate's appointed personal representative to collect the decedent's assets, use the value of the decedent's property to pay the estate's debts or expenses, divide any remaining funds after these payments are made among the decedent's heirs or devisees, and take any other action authorized by law on behalf of the decedent's estate. The personal representative is obligated to act in a reasonable manner that will not result in any loss to the decedent's estate, and must be diligent in settling the decedent's estate. If the personal representative fails to act in the required manner, he or she may be removed from that role. After preparing your paperwork in accordance with this tutorial, you may bring your documents and the filing fee to the Mecklenburg County Courthouse and drop them off with the Estates Department, or you may mail these items to the following address: Clerk of Superior Court, Estates Division, P.O. Box 37971, Charlotte, North Carolina 28237. I hope this information has been helpful. We look forward to assisting you.